What happens when the judge gets it wrong? When parties invest a lot in trying their case before the court, oftentimes there are winners and losers. And so it's not surprising that one party decides to appeal the judgment of the court. And while judges often try to apply the law to the facts and to get the right outcome, sometimes they get it wrong. Our guest here today is Liisa Speaker. She's the owner of Speaker Law, located in Lansing, Michigan. She's licensed in Texas and in Michigan and is well respected by her peers. She's a member of the American Academy of Matrimonial Lawyers, and she's recently authored a book called Kids Caught in the Middle: How Families Are Harmed When Judges Don't Follow the Law. She's here today to talk with us about the appellate process, how it differs from regular litigation, and what families need to know when they're entering the legal system. Liisa, thank you so much for coming to be with us today.
Well, Jennifer, thank you for having me. It's very good to be back in Dallas.
Excellent. Well, I want to start off by just asking you, in your appellate practice, what kinds of cases are you dealing with? What do you see most often going up on appeal?
So our firm does specialize in appeals, and we do family law appeals, which also includes child welfare cases and adoption appeals. But within the family law realm, we get a lot of post-judgment custody cases. And yes, we do have a lot of other kinds of family law appeals, but it seems like the post-judgment cases are the ones that actually get litigated more because they aren't able to settle like they were earlier in the case.
So let's talk about what does post-judgment mean? And
okay.
And I know what it means, but I'm going to let you kind of help us understand what are we talking about here.
Absolutely. So let's just say we have a husband and wife are getting divorced, and then they go through the process of getting a judgment of divorce. And a lot of times what happens is they are able to work it out. They're able to come up with a settlement for spousal support and property. They come up with an agreement about how they're going to have parenting time with the children. And so it doesn't ever go to litigation. It never has a decision that's made by a judge. It's a consent judgment. Well, fast forward 2, 3, 5, 6 years, depending on how old the kids are, and their lives are changing, right? Maybe one of them wants to move to another state, or they've changed jobs, they've remarried, the kids are getting older. The kids are no longer in elementary school, they're in middle school, and they're involved in sports. So all these things are happening in the life of the family because the family is constantly changing. And then somebody wants to change custody or wants more parenting time or wants to change the situation for some reason. And that's when we get the post-judgment, it's post-judgment of divorce usually, motion to modify custody. And those are the cases that are more likely to be litigated because at that point, people are entrenched in their lives and what they want to do with their own separate worlds. Because before it was one world being divided into two, now we have two entrenched separate worlds. And people are not willing to come to the table as much to come to an agreement that's going to be for the best interest of the children. So they end up going to court and having a judge decide what custody should be.
And of course, we do see that a lot. I know, for example, the geographic restriction, which is really common in our family courts here, and I'm sure it is in Michigan as well, that ends up being one of the most challenging issues to litigate when a parent wants to move away with the kids. And there's not really usually like a happy medium. Like everybody just ups and moves to the middle ground. It doesn't really happen.
It's not. It's hard when in Michigan, at least, when you have both parents have legal custody, you have to convince the court that a change of domicile is appropriate, and there's a special test that you go through. And I know it's very similar in Texas. I have 2 cases right now where a mother wants to move from Michigan to Texas. And both of them have jobs in Texas. One is in San Antonio, one is in Dallas. And mom, primary caretaker, wants to move to improve her life. The judge says no. And then we have to appeal that decision to give that parent a chance to improve the family's life and financial well-being. But it's hard. It's hard for the left behind parent too. Especially if the left behind parent was really actively involved. Now, there are a lot of cases where that parent really was not exercising parenting time, where they kind of were just not playing all in with their family until the day that their ex-wife or the mother of their child said, hey, I want to move the child across country. Then they're like, oh, I better start taking this seriously. But there are repercussions on both sides.
I'm smiling because I'm happy to know that also happens in other states besides Texas. So yeah, I would say this is probably one of those issues that is really complex. So So what happens? I mean, how do the judges get it wrong? Well, I guess I would start by saying, what's in the judge's discretion to decide, and then how do you appeal that?
So there's two basic things that the judge decides. They decide how to apply the law, and they decide what the facts are. So sometimes if you have a jury or you have a judge, they're the ones that get to decide what the truth is. And then we have the law, and the law is more or less black and white. And so what we see for appeal is that, the parents will come to us. They don't know what the judge messed up. They just say, hey, I got this result. I'm not happy with it. I was a primary caretaker, sole legal custodian, sole physical custodian, and now this person, the man or the woman, whatever, who wasn't really involved with the children's life, now has sole physical, sole legal custody, and they're like completely distraught because the children they spent all their time with are like hardly with them anymore. The whole schedules are flipped, and so they don't know whether it's a legal or factual mistake. So we have to start digging into what happened, and the factual mistakes are really hard to appeal. If all there is a factual mistake, like the judge didn't believe your witnesses and didn't find them credible, that's really hard to appeal because the trial judge gets to decide whether the witnesses are telling the truth or not. And they get to decide what the facts are. And you can appeal if it's what, quote, clearly erroneous fact finding, but that's still a harder appeal to pursue. What we find is that more often when we have success on appeal, and we do have a lot of success on appeal, it's because the judge did not follow the law or misapplied it in some way. And so, for example, for post-judgment modification of custody, there's a series of steps you have to go through. You can't just rip a kid out of the custodial environment that they're familiar with and just change it overnight because you're on a whim. You have to go through this series of tests. And you were saying in Texas, for example, it was substantial change, right?
Material and substantial
change is the Texas test. And we have something very similar to that in Michigan. And so if the judge skips that step and then just goes through and makes a custody decision, that could be a legal error. Or, for example, we have best interest factors. I'm assuming that we have them in Texas too. And I didn't practice family law when I was in Texas. I am a full-time family law attorney now, but in Texas I was a commercial litigator. So if they don't go through all the best interest factors, I mean, that's a legal error. So there's a lot of things that come up in children-related cases, especially where the judges just don't follow the law. And sometimes it's because they don't know the law or they don't take the time to figure it out. Or sometimes it's like a unique factual scenario. The way it's come up through the courts, it's not cut and dry. It's not really easy to figure out. It takes some explaining. And if they don't have attorneys on the case who are able to articulate what the standard should be, it's easier for the judges to make mistakes.
Yes, and that makes sense. And I know in Texas, at least, you have to have the material and substantial change, and so families will go through the whole litigation process and get through. Maybe the judge found there was a material substantial change, but it'll go up on appeal and it'll get overturned on appeal because the appellate court said it not substantial, not material, and so then it comes back down. What is the difference between a trial to a trial judge versus an appeal case when you're arguing at the appellate level? I think there's a mistaken notion I find that people get to retry their whole case if they take it up on appeal.
So they are significantly different. It's like a whole different forum, different venue. You have an audience on appeal of 3 judges who are appellate judges, and in the trial court you have the one judge who heard the case and decided the facts and decided how to apply the law. And on appeal, we're stuck with the quote-unquote record that was created in the trial court. So what we find a lot is parents will call us and say, well, my attorney didn't present this evidence, or they didn't do that, or there's more things that have happened in the 5 days since the judgment was entered. Well, none of that's part of the record. We can't talk about it on appeal unless it's actually been presented to the trial judge. And the reason for that is because on appeal, you're arguing that the trial judge made a mistake. So if the trial judge did not know about this, stack of documents, how can you say the trial judge made a mistake in not considering documents the trial judge didn't know about? So it's all has to be based, the trial judge's errors have to be on the record and from the documents and the testimony that was presented to the judge.
I was just going to clarify, when we say on the record, there's a court reporter who is taking down the testimony, the arguments, the objections, the court's rulings on all of that. And it's all contained in a transcript.
Right.
And that's one of the most important things. If you are going to take your case up, on appeal, or you wonder if you have a case, you have to get the transcript.
And in addition to the transcripts, there's the exhibits that were admitted at trial, right? So the judge has seen a copy because they were presented to him or her during trial. And getting the transcripts is very costly. And a lot of times for some people, just that cost alone is a burden that, if you had, we've had cases in our office where there was like over 20 days of trial. Well, guess what? When you have over 20 days of trial, it's going to be at least $8,000, $10,000 in transcripts. That doesn't include the time that it's going to take to review all of those transcripts, to figure out what happened, to be able to tell that parent's story to the Court of Appeals by writing a statement of facts, to figure out what the trial court did wrong and how they misapplied the law, or what their clearly erroneous fact findings were. Sometimes we also argue that the trial court's ultimate decision was against the great weight of the evidence. So, those are hard appeals, but we have done them and we've won them. But you can't expect to win every case when it's, the factual appeals.
And I think raising the cost of an appeal is really important for people to understand, because, I think it begs the question, can we live with the outcome? Maybe the judge didn't get it right, but is it okay? Because it can be very, very costly.
Right. And so for our clients, we have people that will call us complaining about financial decisions, for example, like the judge assessed sanctions and a parent has to pay, $500 or $5,000 in cost to the other side. Well, it most likely will be much cheaper just to write that check and pay it than to try to appeal it, because it's going to cost more to appeal it than what it would be just to pay the check. You don't want to have a client who just wants to appeal on principle, because we're talking about a family here. And it's just having litigation and appeals are disruptive to the family. But when it comes to children, the viewpoint's pretty different, because people are fighting to have relationships with their children. And that's where, like, okay, if we're talking about one overnight was changed, well, I'm going to probably be telling the potential client that, that's not going to be worth appealing. Right. Not just because the Court of Appeals probably won't agree with us, but are you really going to spend your resources, even if you have unlimited resources, are you really going to spend your resources to fight over one overnight a week, or like some modest amount? But when cases that come to our office, they've changed the schedule, where they had the kids all but 4 days a month, and then the schedule's completely reversed. I mean, they have basically no choice but to appeal if they hope to regain that relationship with their children and have that time with their children.
I think what you're touching on is one of the things that you and I both share in common, which is the commitment to our role to really be a counselor and advisor to our clients. So, it's easy to take money and to put a fight together, but, you have to look at the whole family dynamic and, the outcome and the lives of our clients being wrapped up in litigation and an appeals process. It takes not just money, but that time that you don't get back.
And a lot of time the clients are, they've been living it, and it's hard for them to see the forest through the trees. And, we have to make recommendations once the client's hired us, and maybe we have to order the transcripts to be able to figure out what actually happened. But we have many times where we have to tell them, this appeal is not really going to be worth it. Either because there's no way you're going to win, or the chances of winning are so slim. It's just not going to make sense for you to use your resources. Maybe you'd be better off going back to your trial attorney, maybe paying your trial attorney to do another motion in 6 months, or whatever the case may be, or a year, or use it for therapy, or, whatever, whatever. But appeal is not always the best choice.
Right. But I think it is important also to understand that appellate process is a really important check in our legal system to make sure that judges are following the law. And so sometimes people, they may think it's all up to the judge's discretion, that, the fight is to get the judge to like you, and so that the judge rules in your favor. I'm just wondering, as an appellate attorney, what do you often see as the most kind of the common mistakes that are made maybe by the trial attorneys. I think that's a good question to ask. And also, by the judges when they do get it wrong.
So from the judge's perspective, a lot of times the mistakes we see are they don't make fact findings. They hear all this evidence, but then they kind of forget to go through the statute step by step and make findings to support their decision. So you go through the statute and say, yeah, I think this parent or that parent should have sole custody. But if you don't actually make specific findings under each element of the statute, you're more likely to have made a mistake. Maybe not. I mean, maybe your decision's perfect, but if you don't have fact findings, you're probably going to get reversed. Because the Court of Appeals can't guess what the judge was thinking. They have to, they can't tell from the decision what the judge was thinking. They're going to be like, well, we can't just assume the judge was doing the right thing. We have to see it on paper. With the attorneys, there's a wide variety of attorneys with a lot of different experiences. And so we have like two groups of attorneys that we get cases from. We have the people that are good friends that are, very well versed in family law, are very dedicated to family law, that go to family law conferences. I would say that would be like you, Jennifer, here in Texas, and they know when they're over they don't think they know everything. They're willing to ask questions during the process. They call us in the middle of trial because they want to make sure they get it right. They're really good attorneys, and they're cognizant that they don't know everything. And then there's attorneys that maybe we don't know as well, who you read, and a lot of those aren't the attorneys that are referring us cases. Their clients are finding us by some luck of the draw, that they've come across us somehow, and we're seeing like what they've done in the trial court. They haven't filed the motions that they needed to file. They haven't made the objections they needed to object. They haven't, when the judge is starting to plow ahead without making findings, are not trying to stop the judge to like, Your Honor, we need to have findings on this. So there's like a wide variety in attorney skill set, I guess.
Yeah, and I think it's really important. I know when we're going into trial to at least be consulting with that appellate attorney to make sure you've kind of fleshed out, what are the questions of law, where is the judge's discretion, and really be ready to argue that. And having an appellate attorney as part of your team is important. So I think it's, we do have great relationships with appellate attorneys here in Texas, and I think it's really important. What obviously, like, landing in your office is not something anybody desires to do. You don't want to be stuck in an appeal. What is some good advice for how to avoid an appeal?
Okay. First of all, I wanted to say that I've noticed in the past 2 months, we've had more repeat clients than we ever had. We, occasionally we'll have a client who comes back for another appeal, but we have like 6 custody clients right now who've appealed before, and now they're hiring us again because something else has gone wrong. And you don't want to be that parent. I mean, I love my clients, but you don't want to be the person that's going to have to appeal the judge multiple times. I mean, if you have to, they have to, and they will. And we've had success on cases multiple times on the same case until we can get that judge, if there's a way to get a judge off a case, or maybe they retire, we get a different judge. But it's just really interesting that there are times when we have to see the same family again. And it's sad because you don't want them to you want them to be able to move on. And
right.
You went on appeal, you want them to have success after that. You don't want them to ever have to call you again. And it's really a little bit heartbreaking when they have to call you again because things aren't going well. And I forgot your question, so you'll have to repeat it.
I was asking you, like, how to avoid an appeal.
Yeah.
What advice do you have for families
absolutely.
if they're entering into litigation? What can they do to like minimize the likelihood they're going to be stuck in an appeal process for years?
So you have to start thinking about this very early in the case. It's how you approach the litigation. Are you going to keep an open mind and be reasonable and try to negotiate and try to come to a reasonable settlement if there's conflicts? It's going to impact who you hire. Are you hiring somebody who's going to be really aggressive, that's going to fight to the death without willing to concede anything, who's going to generate a lot of paper, require the other attorney to respond? I mean, how aggressive is the litigation going to be? And if you don't have to have a weak attorney. That's not what I'm suggesting at all, but you need to have somebody who's strong and professional, who's going to be willing to help you resolve it. So the way to avoid the trial and then the appeal is by being willing to settle and willing to talk to the other side to resolve your issues. And so what happens with family law cases, when they do go to trial, there's always going to be somebody who's almost always is going to be somebody who's completely unhappy. Now, sometimes both sides are unhappy and they both end up appealing. But usually if both sides are unhappy, they just like chalk it up. Okay, we are going to move on and we're going to just live with the situation. But when one party loses everything and the other party gains everything, there's pretty much, you don't have a choice. You have to appeal. But to avoid appeal, you basically need to be open to settling if that's appropriate. Now, the problem we see in a lot of our cases is that one parent is very unreasonable. So you can be the nicest, kindest, most open, reasonable person, hire the best attorney who's going to be just like that. And if the other side is not like that, you're not going to be able to settle it. So there's cases that go to trial where there's something going on and the judges know it. They know something's going on. Now, sometimes they guess wrong and they think it might be about your client when it's actually about the other side, or vice versa. Like, you know, our clients aren't perfect either. We have clients that have issues. There's clients that have mental health issues, or, you know, they have control issues. And there's a lot of things that they're making bad decisions about how they're raising the children and not even how they're raising the children, but how they're interacting with the other parent. So one way to avoid litigation is to think about how you're interacting with the other parent. You know, using our family wizard, if you have a more contentious relationship, helps because you don't have as much engagement with each other. But there's parents that just seem to engage with each other at parenting time exchanges, and it just...
I can't help but to think of Kanye West, right? Like kind of this hot topic of the day with kind of the online, you know, bullying that happened. And, you know, when you see a client who's kind of, or the opposing party is acting out like that, if it's a client, you know, it's scary as the lawyer because you know that there are serious repercussions coming. And it's so important for people to really just be very aware of the emotions that they're feeling and really cognizant of the impact that they're having.
I mean, you know, parents, and I'm not saying this in a negative way, they might need to have therapy. And that's not a bad thing. If that can help them understand their feelings and their frustrations with having to deal with a co-parent. I mean, that was not their plan. I'm guessing to have to co-parent with this other person. And now they're being forced to run everything by this person who maybe, you know, they have a lot of issues for other reasons, like they cheated on them or whatever, you know, like there's all this history.
I mean, it's
feelings. Right.
It's one of the things that makes family law very challenging, is because we know, you know, we're dealing with people at a very raw time. And, you know, I always feel like it's my job to help them kind of, you know, see the big picture, to kind of reclaim the vision for their lives. So they're not stuck in that space. It's a hard space to be in.
And it's not just feelings. There's obviously parents who are domestic violence victims or domestic violence survivors, but they're being put maybe in a position where they have to deal with an abuser on a regular basis because they have to do parenting time exchanges and they have to make decisions together. So it can be a handful. And it's not always the woman who's the one that's abused. I mean, sometimes it's the man that's been abused. So it's, you know, not gender specific.
It's an important point. And I think, you know, the great thing about the legal system is that we do have a process to bring resolution. If parties cannot find that resolution themselves, then we have the judge to make the decisions. And, you know, I think one of the things that's important that I always talk about with my clients is just the fact that when you take those issues to court, you are asking somebody who doesn't know your family to be the decision maker. But at least you get closure with it. And unless unless it's the wrong decision, and then they get to know somebody like Liisa Speaker. You know, one of the things you and I were talking about was the importance of who the judges are, and kind of knowing the judges and, you know, where you're practicing. And, you know, we elect them here in Texas. I don't even know if a lot of people know that our judges are elected. And
ours are elected as well, and they're appointed to fill a vacancy if somebody retires or passes away or whatever. They are appointed for the end of the until the end of the term, and then they have to run again. And
so it's really important for people to know when the ballot time comes around who they're electing. What advice do you have?
Now there's two different things going on. the election of judges and then knowing your judges. So first of all, parents don't have a choice on who their judge is. They don't get to decide that. But knowing who your judge is and knowing like what their weaknesses and strengths are probably going to be helpful. For example, if you know that they were experienced family law attorneys before they were on the bench, will maybe give you some comfort that they'll at least try to understand the law and apply it correctly. But not everybody that gets on the family law bench has that background, and maybe they're learning it for the first time. And, there's a lot of issues with that. Knowing the judge's demeanor. I mean, you're going to know, your trial attorney is going to be able to know what kind of experience they should expect. And usually the attorneys do know what to expect from the judge as far as the personality and how you should behave in court, because this judge might react a certain way to certain people. Now, as far as election of judges, that's a very interesting topic. So here's the thing. In my experience, it feels like the regular folk don't know who any of the judges are. And I get it. Only the attorneys know who the judges are.
Right.
Unless you're one of those unfortunate people who's had to litigate a case. And most people, all Jennifer and I do is family law, but at the same time, most people don't have cases that go to court. So we represent a very small group of people. And those people will be very active, to vote for or against a judge they don't like. If they felt, it's not even about winning or losing. It's if they felt they were treated with respect and dignity.
Oh, that's so important.
I think it's not that the judges, it's not that the judge agrees with you or disagrees with you. How do they treat the people in their courtroom? And some judges are not nice, and other judges are really professional. And, that's a personality thing that your trial attorney should know about. But as far as election, most regular people don't know who the judges are. And, whether they're bubbling it in based on whatever, if I don't know if we
party affiliation.
We don't have party affiliation for our judges, but if you're in Texas, you do, or the gender or whatever, or if they're incumbent or not incumbent. I mean, that's not really making a informed decision.
Right.
So I think a recommendation would be to try to make an informed decision, because these judges are really important and they're going to affect a lot of lives.
Well, they're really important in our community, and the impact that they have. Even if you are lucky enough to never have to end up before a family law judge, you probably have friends or family members who will, and that judge is going to have a significant impact in the lives of our community.
Yeah.
So I think this has been a great discussion. I really appreciate you taking time, and I guess I would just ask you to think about a message of hope. If somebody is embroiled in litigation, what message of hope would you have for them?
Well,
in a family law battle.
I figured, my hope for the client would be that a judge up the chain will see the case the way it really is, if that's what happened. And obviously a lot of times I feel that that's my client's position, but not always. Sometimes, your position, we appeal and we don't think our position is as strong as other cases. But when you've seen a real wrong, and this book has a lot of examples of wrongs where custody was taken away inappropriately without following the law, and it was just a complete injustice. And you want to give clients hope that you're going to have an attorney who's going to keep fighting for you, who's going to keep on working to keep your family together. And the reason I wrote the book, as an appellate attorney, we talk to new clients and they have factual issues or legal issues, and we get really excited when, oh my gosh, the judge didn't follow the law. That's going to make a great appeal. And it's a great appeal because we know the chances of us winning are higher. But the reason I wrote the book is because, winning is great. I love winning cases, right? And I love having judges know that they didn't follow the law and having other judges tell them that they need to fix it. There's a real high off of that. But the reason I wrote the book is because people's lives are forever impacted when a judge makes an erroneous decision and changes custody, for example. And if the whole litigation and appeal process takes a year or two or longer, that's going to impact that child for the rest of their lives. So you get it reversed on appeal, but that child has lost out on time with a parent that they should not have lost out on. And there's a real injustice there. And that's kind of the mission that I have, is to get judges to follow the law, because, what are we doing to our children when we owe it to them, the judges owe it to them to follow the law. And if they follow the law, judges are human beings. They make mistakes. But when they follow the law, it's more likely that they're going to get the right result. If they just make a decision without regard to whether they're following the law or not, they're more likely to make a mistake, even factually. They think they're getting it right because it feels right, but that doesn't mean it is right. And if you don't follow the law, you're just taking a risk that you're destroying a family. I mean, I guess for your own ego. I don't know. You got to follow the law.
Right,
so that's my mission, is to get judges to follow the law. And frankly, if we had some significant changes in our family court system, which I know is a lot different than yours in some ways, maybe there wouldn't be as many family law appeals, and that's okay. You know, like I can do other kinds of cases on appeal. Like I love working on custody cases and adoption cases, but it's hard because you know that some child is going to be impacted for the rest of their lives based on what happens in that case.
That's exactly right. So, Liisa, thank you so much for your dedication to making sure that justice is served to the people who need it most, which are our children. If you want to learn more about Liisa and her book, we're going to include a link to her website, and we hope you follow up. And I would encourage you to read her book so you can be empowered about the legal system, about where we get it right and where we get it wrong. And thank you for joining us. And of course, we'd love for you to subscribe, leave a comment down below. And until next time, we'll see you then.